Hello, my name's Dr Nandasoma. I'm one of the team of medico-legal advisors at the MDU, and this is a short video to introduce the GMC's new guidance on decision making and consent. The guidance becomes live on the 9th of November, and I've included a link in the description so that you can access it on the relevant section of the GMC's website. The guidance is relevant to all doctors, though those of you treating patients under the age of 18 should read it in conjunction with the GMC's 0 to 18 guidance. I know you'll all be really busy right now, and I'll try and take you through this guidance as briefly as possible, but I do want to talk very briefly about the context in which this guidance has been developed. What test should be applied to judge whether adequate consent is in place has been a matter of debate for many, many years. Should it be a matter of medical judgment alone? Should it be with reference to what a reasonable patient undergoing a medical intervention might think? Or should it be with reference to the characteristics of a particular patient undergoing the procedure, or essentially the patient in front of you? Up until 2015, the legal test was very much a medical one. In simple terms, if a doctor would not be judged negligent in their approach to consent if they'd follow the practice of a reasonable body of medical opinion. So essentially, consent also fell under the Bolam test. However, when the GMC last updated its consent guidance in 2008, it placed quite specific and rigorous duties on doctors to share information in a patient-centred way, focusing on a duty to share information that a patient may need or wish to know about their treatment. In 2015, the legal test also evolved to become much more patient-centred. I've not got time to go to the details of that case, but many of you will have heard of it, the Montgomery judgment, and I include links in the description again to some relevant articles on the MDU's website. The GMC's new guidance is really an evolution of its past guidance to really take into account those developments since 2008. The guidance takes a principles-based approach, and I've set those out over the next few slides. You'll not be surprised that the emphasis is on involving patients in decision making and supporting all patients, including those who might have factors that could compromise their ability to make decisions in engaging with the consent process. You'll see that there's also an emphasis on trying to find out what matters to an individual patient, and again an emphasis on fully talking about reasonable alternatives, including the option of taking no action. The guidance also deals with how to approach patients who lack capacity, and again that's based on the Mental Capacity Act and is not surprising. We're required to involve those with an interest in the patient's care or those close to them in decision making. And there's also a reference to involve patients even where their right to consent is affected by law, for example, those patients having compulsory treatment. Now, the guidance does go into some detail about how we can apply these principles. There is reference to a proportionate approach. So I think the idea here is that the amount of time and the amount of information exchanged in a consent discussion will really depend on the complexity and the consequences of the treatment. There is some acknowledgement that urgency of treatment may limit the extent of a discussion, though it's still expected that will involve all patients who are conscious in decision making wherever possible. There is also some direction on what information is relevant. That's largely based on the principles set out in their 2008 guidance. And there's also some reflection on how to apply this guidance to the legal principles which have been updated since Montgomery. Now, there is certainly food for thought in this guidance. There's an express statement that a signature on a consent form on its own is no substitute for a meaningful discussion with a patient. That's not to say the consent form is not of no use or it's not important. Of course, understand it is in the context of patient safety and checklists. It's rather to say that our record should reflect more than the content of most consent forms and evidence that we've had relevant discussions, listened to the patient's concerns and priorities, and shared relevant information, and also been clear about the scope of any decisions made. The guidance also encourages doctors to consider advanced care planning where that's relevant, where a patient might be anticipated to have a progressive condition that could impair their ability to engage with decision making in the future. And it also talks about providing objective information on risks wherever possible, and also acknowledging uncertainty where there are uncertainties that can't really be resolved, and where the risks and benefits may need to be re-evaluated as treatment progresses. There are some helpful acknowledgements in this guidance. I know that many of us will be thinking about how we can implement this guidance most effectively when we're faced with the pressures on services as they are currently. I'd emphasise again there's a discussion of a proportionate approach, meaning the amount of time we devote to consent is proportionate to the consequences and the complexity of treatment. There is an acknowledgement that resource constraints impact on our ability to follow the guidance, and it talks about our duties to raise concerns if that is impacting on services. There is also an acknowledgement of multidisciplinary working and delegation. Essentially, it's acknowledged that other members of the multidisciplinary team may play a key role in sharing information as part of providing the patient with information and be a really important part of the consent process. It's also acknowledged that there may be some circumstances where if you've got someone who is properly trained and able to have these discussions, that it's perfectly appropriate to delegate the consent to that practitioner. However, the GMC still maintain that position that if we're the doctor providing treatment, it's up to us to be satisfied that proper consent is in place before proceeding. Finally, the GMC talk about how they'll use this guidance in their fitness to practice procedures. They explain that they're only likely to be engaging doctors in their procedures when there is a serious or persistent failure to follow this guidance. Now, of course, those sorts of issues often come up many years after a patient was treated, and frankly, only time will tell how this will be used in the regulation of doctors. So I hope that was helpful. I know that you've got a lot to keep abreast of at the moment, but this is a revision of one of the GMC's core pieces of guidance that hasn't been updated for some time. So I'd encourage you to spend a few minutes on the GMC website reviewing it for yourself. We will also be hosting a webinar on consent that will hopefully allow us to go into this guidance and other issues surrounding consent in a lot more detail. So please do look out for that. So thank you very much for watching. I hope that's helpful. Thank you for your attention.